Welcome back to the deep dive. Today, we're plunging into a topic that might, at first glance, seem a bit dry, maybe a little academic.
Yeah, it could sound that way.
But trust me, it is absolutely critical, and when you really get into it, genuinely fascinating in the world of information security. We're talking CISSP Chapter 4, Laws, Regulations, and Compliance.
Mm-hmm.
We've taken a comprehensive study guide on this, kind of distilled its essence, and our mission today is really to make sense of the complex legal landscape that governs cybersecurity.
It's a big one.
Yeah. We'll turn that dense material into clear, understandable insights, hopefully uncover some surprising facts, and offer relatable examples just for you.
It's vital, isn't it? And, what's truly fascinating here is how foundational this knowledge is. Understanding these legal frameworks, well, it isn't just for the lawyers or the compliance officer.
You're right, not just them.
No, it's an absolute requirement for every single cybersecurity professional out there. It's really the bedrock for protecting data, ensuring privacy, and even safeguarding our critical national infrastructure.
That's a huge responsibility.
It is.
Yeah.
And without a firm grasp of these laws, you're essentially navigating a minefield blindfolded. You're just unaware of the potential pitfalls and, frankly, the severe consequences that can follow.
And it really is a minefield out there. When you look at the landscape of cybersecurity compliance, it's incredibly complex and, well, always in motion.
Constantly changing.
Exactly. We're talking about a patchwork of overlapping laws. You have national, state, and even the local governments all passing their own rules.
Yeah.
And sometimes these laws overlap, sometimes they actually contradict each other, and the pace of tech change often just outstrips the whole legislative process.
It's a great point. The tech moves way faster.
It does. Imagine trying to follow building codes in a city where every single block has different rules set by different authorities.
Okay, I'm picturing that. Chaos.
Right. Some rules overlap, others contradict, and some even change based on what country you're technically building in. That's precisely the challenge multinational companies face navigating international laws. It's a lot to reconcile, and it requires a really sophisticated approach to compliance.
That's a perfect way to put it, actually. And this complexity, it also extends to how law enforcement operates in the digital realm. Agencies, well, everywhere, have had to significantly adapt to tackle the unique challenges of cybercrime.
They've had to catch up fast.
They really have. Many now have dedicated full-time computer crime investigators with highly specialized security training. And for those agencies without such dedicated teams, it's absolutely crucial to know when and how to call in assistance from more experienced agencies.
Right, knowing who to call.
Exactly. And for us, as cybersecurity professionals, understanding even, basic investigative techniques gives us vital context for how these laws are actually applied in real-world scenarios. And that can significantly influence how we design and implement security controls.
Absolutely. So, to help us make sense of this intricate legal environment, we're going to begin by breaking down the three main categories of laws that form the backbone of the U.S. legal system.
Good place to start.
Yeah. Understanding these fundamental distinctions is really your first step in navigating the legal landscape of cybersecurity. Let's start with what many people think of first when they hear law. Criminal law.
Mm-hmm. The big one.
Yeah. This is truly the bedrock, the foundation of our legal system, designed to preserve public peace and keep society safe. Its core purpose is to prohibit acts that are considered harmful to the public good.
Right. Things that society says are just unacceptable.
Exactly. We're talking about offenses like murder, assault, robbery, arson, and increasingly computer crimes that pose a direct threat to individuals or the public.
Precisely. And when an individual or entity violates criminal statutes, the penalties can be incredibly wide-ranging and severe.
What kind of penalties are we talking?
Well, we're talking about mandatory community service, fines that can be, really substantial, imprisonment, and even the deprivation of certain civil liberties.
Wow, okay.
To give you an analogy, criminal law is like the absolute fundamental rules of a society, much like don't steal your neighbor's car.
Simple, clear rule.
Exactly. Very clear rules. And if you break them, there are severe society-imposed consequences. In the cybersecurity context, this extends to prohibiting direct harm, theft, or disruption in the digital realm. Things like hacking into critical infrastructure or stealing large quantities of personal data for illicit gain.
And how are these laws actually created and enforced? How does that work?
Well, they're passed by legislative bodies at all levels of government, federal, state, and local. At the federal level, both the House of Representatives and the Senate must pass a criminal law bill by a majority vote.
Okay, both houses.
Yes, and then the president typically signs it into law. federal jurisdiction primarily applies to cases involving interstate commerce, meaning activities that cross state lines or offenses against the federal government itself.
And if it doesn't cross state lines?
Then, if federal jurisdiction doesn't apply, state authorities handle the case using laws passed by their state legislators. It's a truly complex system.
Sounds like it.
And all laws, once passed, are subject to judicial review by regional courts, with the right of appeal all the way up to the Supreme Court. A law can even be struck down as unconstitutional, rendering it invalid.
So even past laws aren't set in stone?
Not necessarily. Which leads to some really strong advice here, and this truly can't be stressed enough. If you ever find yourself involved in a criminal law matter, whether as a witness, a defendant, or even a victim, seek professional legal help immediately.
Don't try to handle it yourself.
Absolutely not. It's never wise to go it alone in such a complex system where your rights and your future are really on the line.
You've hit on a critical point about the complexity, and it brings to mind a powerful real-world scenario from our source material that really demonstrates how criminal law applies directly to technology and how quickly investigators can act.
Oh, I think I know the one you mean, the bomb threat.
Exactly. Imagine this. A high school receives a bomb threat via email, threatening an explosion at 1 p.m. The principal gets the alert at 11 a.m.
Wow, only 2 hours.
Just 2 hours to investigate before evacuating the entire school. So the lead investigator immediately issues emergency subpoenas to internet service providers, that's ISPs, to trace the email's origin.
Okay, cutting through the red tape fast.
Right. And here's where it gets truly fascinating. By 12:15 p.m., less than an hour and a half later, they're confronting a suspect in the school library.
That's incredible speed. How?
They had surveillance tapes and audit logs that conclusively proved the email originated from that specific computer right there in the library. The perpetrator thought they were anonymous online.
Big mistake.
Huge mistake. They were absolutely wrong. This case just vividly highlights how seemingly untraceable acts online have serious criminal consequences and how digital footprints are often far more revealing than people realize.
Yeah, that's a powerful example of digital accountability. You really can't hide online as easily as some people think.
Definitely not. So if criminal law is about public order and severe penalties imposed by the state, civil law operates in a fundamentally different arena.
Right, a different purpose entirely.
Yeah, it forms the bulk of the U.S. body of laws designed for an orderly society and to govern matters that aren't crimes but require an impartial arbiter to settle disputes between individuals or organizations.
Okay, so disputes, not necessarily crimes against the public.
Exactly. Think of common examples like contract disputes, maybe disagreements over real estate transactions, employment matters, or estate and probate procedures.
Right, things that need sorting out between parties. The core purpose here is to provide a neutral third party to resolve conflicts fairly, ensuring a just outcome in disagreements that don't involve a direct threat to society as a whole.
And the consequences are different too, right?
Oh, very different. The key difference from criminal law is that there's generally no threat of imprisonment. Instead, penalties are typically financial. You often hear about multi-million-dollar cases in the news. Think of major class action lawsuits or disputes against large corporations.
So money is usually the outcome.
Usually, yes. And the government, unlike in a criminal case, doesn't take sides in the dispute. It acts more as a facilitator, providing the judges, juries, and court facilities.
Okay.
To use another analogy, civil law is like the rules of a neighborhood association. If you have a dispute with your neighbor over, say, a fence line, you go to a neutral arbiter to settle it, not the police.
Got it. Less severe, more about resolution.
Exactly. In a business context, it's about settling arguments, like a breach of contract for a software development project, or maybe a company being sued for a data breach where they failed to protect customer information adequately.
Yes.
The focus is on making the wronged party whole, usually through financial compensation.
That makes perfect sense for settling disputes between parties. But what about the vast machinery of government itself? Who sets the rules for how agencies like the Food and Drug Administration, the FDA, or immigration operate day to day?
Ah, good question. That brings us to administrative law. This category originates from the executive branch of the U.S. government. The executive branch charges numerous agencies with wide-ranging responsibilities to ensure daily government functions run smoothly.
So the rules for the rule makers, kind of?
Sort of, yeah. These agencies have the leeway to enact their own administrative laws, which are essentially specific orders, policies, procedures, and regulations to govern their daily operations and fulfill their mandates.
Where do you find these laws? Are they published somewhere?
Yes, they are. These administrative laws are published in the Code of Federal Regulations, or CFR, making them publicly accessible.
CFR. Okay.
Now, a critical point here is that administrative law does not require a legislative act, meaning it doesn't need to be passed by Congress.
Oh, interesting. So agencies can just make rules.
Well, within limits. It must comply with existing criminal and civil laws, and it's also subject to judicial review. That means courts can overturn administrative rules if they find them to be, say, arbitrary, capricious, or outside the agency's legal authority.
So there are checks and balances.
Absolutely. You can think of administrative law like the specific operating procedures for a factory or a hospital. They're not the big, overarching laws set by Congress, but rather the detailed rules and regulations set by the management, or in this case, the executive branch, that ensure daily operations run efficiently and safely within the bounds of broader legal frameworks.
And this is relevant for cybersecurity.
Very relevant. For cybersecurity professionals, this is particularly important because many key compliance standards, like those from the National Institute of Standards and Technology, NIST, actually originate from these administrative mandates.
Ah, okay. NIST comes from this area. Got it. So bringing all these categories together, criminal, civil, administrative, correction, what does this actually mean for you, our listener, as a cybersecurity professional? How does this break down in practice?
Well, for you, understanding these distinct categories is absolutely crucial for ensuring compliance within your organization and navigating legal issues effectively. Each type carries different implications for information security.
Can you give an example?
Sure. Preventing direct harm and theft in the digital realm through robust security controls, that falls under preventing criminal acts. Managing contractual agreements and avoiding liability in civil disputes like a data breach lawsuit, that's the civil side. And finally, adhering to specific agency regulations that dictate how you handle sensitive data, like NIST guidelines under FISMA, that's administrative law.
So you need to be aware of all three.
Absolutely. It's your responsibility to be aware of which legal category applies to a given situation and, critically, to know when to seek professional legal help, especially when you're in a legal gray area or dealing with significant incidents. Your actions, or maybe your inactions, can have consequences across all three of these legal domains.
That clarity is invaluable. Now, let's transition from these broad legal categories and really deep dive into the specific laws designed to tackle computer crime itself.
Right, the cyber-specific stuff.
Exactly. Early attempts to prosecute cybercrimes often tried to apply traditional criminal law, but it quickly became clear that this was, well, the source material calls it too far a stretch.
Yeah, fitting a square peg in a round hole.
Pretty much. The digital world just didn't fit neatly into existing definitions of things like theft or trespass. So legislators responded by creating specific statutes to address this modern type of crime.
Makes sense. New crimes need new laws.
And it's important to remember that while U.S. federal laws are often paramount because the internet is global, state laws can often be more restrictive or impose harsher penalties. So you get this layered compliance challenge.
Definitely. You have to watch both federal and state levels. And the very first major piece of cybercrime-specific legislation in the United States was the Computer Fraud and Abuse Act. That's CFAA. Originally passed way back in 1984.
1984, wow. Ancient history in tech terms.
Almost. This act was later significantly amended in 1986, becoming a core part of the Comprehensive Crime Control Act, or CCCA.
Okay, CCCA, what did the original CFAA actually outlaw?
The original CFAA made it a crime to perform several actions, things like accessing classified or financial information without authorization, using a federal computer for fraud, causing malicious damage to a computer system in excess of $1,000.
Only $1,000 damage. Seems low now.
It does now, yeah. It also covered modifying medical records or trafficking in computer passwords if it affected interstate commerce or federal systems.
So it was a pretty narrow focus at first, mostly on federal systems and specific types of data, but it sounds like it had to adapt quickly.
It absolutely did. The CFAA continued to evolve because, well, technology moves so fast. Congress quickly raised that damage threshold from $1,000 to $5,000.
Okay, a bit more realistic.
A bit. And crucially, they significantly broadened its scope to cover what they called federal interest computers.
What does federal interest mean?
Good question. This included any computer used exclusively by the U.S. government or by a financial institution, or crucially, Any combination of computers used to commit an offense when they are not all located in the same state.
Ah, so crossing state lines made it federal interest.
Exactly. So it wasn't just about direct federal government systems anymore. It was about systems with a broader national impact, recognizing how interconnected our digital infrastructure was becoming even then.
So the analogy, how does that fit?
Think of the CFAA as the first major federal law explicitly saying you cannot break into digital property, especially if it's related to the government, a bank, or has national reach. The original $1,000 damage threshold was like saying don't break a window worth more than $1,000,
Okay.
but then it expanded to cover breaking any window with a federal connection, almost regardless of the initial damage amount if other conditions were met.
And the CFAA was further amended later on, right? What were the big shifts that came with those changes?
Yes, absolutely. The CFAA was further amended in 1994 with what was called the Computer Abuse Amendments Act. This was critical because it outlawed the creation of any type of malicious code-think viruses, worms that could cause damage to a computer system.
Ah, so not just using it, but creating it became illegal.
Precisely. Before this, prosecuting someone for simply creating a virus was legally tricky if it hadn't yet caused direct financial damage. It also modified the CFAA to cover any computer used in interstate commerce.
Interstate commerce. That sounds like almost everything now.
It's a much broader definition than just federal interest computers, yes. It extends its reach to almost any internet-connected device these days. What's more, it allowed for the imprisonment of offenders, regardless of whether they actually intended to cause damage. It focused more on the act itself.
Intent became less important.
For some provisions, yes. And it also provided civil legal authority for victims to seek injunctive relief and financial compensation for damages, so victims could sue. Later amendments continued in 1996, 2001, and 2008, consistently expanding its scope and penalties.
Now, I know these amendments, particularly around the phrases authorized access and terms of service, have actually led to quite a bit of controversy and legal debate over the years. Can you elaborate on that?
You're absolutely right to bring that up. Those concepts, authorized access especially, have been at the heart of some very high-profile and sometimes quite contentious cases.
Like the Aaron Swartz case.
Exactly. Many listeners might recall the tragic case of Aaron Swartz. He was prosecuted under the CFAA for downloading academic papers from MIT's Network Massachusetts Institute of Technology. Prosecutors deemed this a violation of website terms of service, essentially unauthorized access. His case sparked a huge debate about the law's potentially broad interpretation, and some argued prosecutorial overreach.
And the Supreme Court has weighed in more recently?
Yes. More recently, the Supreme Court weighed in with cases like Sandvik v. Barr in 2020 and significantly Van Buren v. United States in 2021. These rulings clarified things somewhat. They stated that the CSAA doesn't apply to mere terms of use violations in many contexts, or in Van Buren's case, where someone has authorized access to a system but then obtains information from files or folders, they are not technically authorized to access within that system.
So it narrowed the scope a bit.
It did, particularly regarding exceeding authorized access once you're already legitimately in a system. This really highlights how dynamic these laws are, constantly being reinterpreted and refined by the courts, and how broad legislative language can sometimes lead to unintended consequences or applications.
That really underscores the importance of staying informed about not just the laws themselves, but how the courts are interpreting them. What came after these foundational cybercrime laws? What was the next step?
Following that, the National Information Infrastructure Protection Act, that's NIIPA, of 1996, added another set of significant amendments to the CFAA.
NIIPA. Okay.
It further broadened the CFAA to cover computer systems used in international commerce, in addition to systems used in interstate commerce. And crucially, it extended protections to portions of the national infrastructure beyond just computing systems.
What kind of infrastructure?
We're talking about vital physical assets.
Yeah.
Things like railroads, gas pipelines, electric power grids, telecommunication circuits, really critical stuff. Any intentional or reckless act that causes damage to these critical portions of the national infrastructure became a felony with severe penalties.
So expanding beyond just computers to the things computers control or rely on.
Exactly. If the CFAA protects the digital houses, then NIPA explicitly said, now we're protecting the roads, bridges, and power lines that connect those houses across state and international borders, because damage to them affects everyone and poses a potential national security risk.
Okay, that makes sense. So we've seen how laws evolve to directly combat cybercrime and protect critical infrastructure. What about establishing a framework for how the federal government itself handles cybersecurity? How do they get their own house in order?
That's where the Federal Information Security Management Act, or FISMA, of 2002 comes in. FISMA was a truly landmark law. It required all federal agencies, and importantly their contractors too, to implement comprehensive information security programs covering their operations.
All federal agencies. That's huge.
It is, and it replaced earlier, less comprehensive acts like the Computer Security Act of 1987. Now, what's really important here is the role of the National Institute of Standards and Technology, NIST.
NIST, right. We hear that acronym a lot.
You do. NIST is a non-regulatory agency, but it's centrally responsible for developing the implementation guidelines and standards for FISMA compliance. They provide the how-to.
Yes, NIST's role is absolutely central in so many areas. What are the key elements of an effective FISMA program that agencies actually have to follow, according to NIST?
An effective FISMA program, guided by NIST, includes several key elements. Agencies must perform periodic risk assessments they need to understand the magnitude of harm that could result from unauthorized access or disruption.
Assess the risks first. Makes sense.
Then, they need to develop and implement policies and procedures based on these risk assessments to cost-effectively reduce risks throughout the organizational lifecycle. This includes creating subordinate plans for adequate security for networks, facilities, specific systems, the whole shebang.
What else? Training? Testing?
Absolutely. Security awareness training for all personnel is mandatory, as are periodic testing and evaluation of security policies and procedures. You can't just write them and forget them.
Gotta make sure they work.
Right. And finally, effective programs require robust processes for planning, implementing, and evaluating remedial actions when things go wrong, as well as detecting, reporting, and responding to security incidents, and of course, ensuring continuity of operations. Business continuity is key.
So it's a whole comprehensive framework.
It really is. You can think of FISMA as a federal mandate for all government departments to have a rigorous, detailed safety plan for their entire building, not just the front door. And NIST provides the comprehensive blueprint for that safety plan.
And the evolution didn't stop there. In 2014, we saw a series of significant federal cybersecurity laws that further refined the landscape. What happened then?
Indeed. 2014 was another big year. The Federal Information Security Modernization Act of 2014, often called FISMA 2014, updated the original FISMA.
Okay, so an update to FISMA, what changed?
A major change was centralizing federal cybersecurity responsibility with the Department of Homeland Security, DHS.
Ah, DHS took the lead.
Mostly, yes, with some notable exceptions for defense-related security, which remain under the Department of Defense. Additionally, the Cybersecurity Enhancement Act of 2014 specifically charged NIST with coordinating nationwide work on voluntary cybersecurity standards and best practices, especially aimed at the private sector.
So NIST's role expanded beyond just federal agencies.
In a coordinating sense, yes. And this act was amended again in 2022 to strengthen cybersecurity research and development, workforce initiatives, and public awareness. NIST's special publications, the SB series, especially those in their 800 series, are incredibly useful resources for practitioners looking for detailed guidance.
The 800 series, yes, very well known.
And of course, the NIST Cybersecurity Framework, the CSF, is a widely adopted voluntary risk-based framework for securing information systems. That directly stemmed from this legislative push.
So the CSF came out of this 2014 activity.
Largely, yes. And lastly, the National Cybersecurity Protection Act of 2014 also charged DHS with the broader leadership role in national cybersecurity. So, in essence, the 2014 laws are like updating the entire building code to address modern threats, making sure a central authority like DHS oversees the federal building safety, while NIFT continues to provide the essential best practices and toolkits for everyone, public and private sector alike.
Okay, that clarifies the 2014 updates. Now, moving on from direct computer crime and government security frameworks, let's shift our focus to something equally valuable, but maybe less tangible. Intellectual property, or IP.
Ah, yes, the crown jewels for many companies.
Exactly. This isn't about physical assets, but incredibly valuable intangible ones, like brand names, artistic creations, or secret formulas. America's role in the global economy, it's increasingly shifting towards being a provider of services and intellectual output. That makes IP protection immensely important.
Absolutely critical. Think of the immense value in company names like Dell or Coca-Cola's secret formula, or that unique blend of herbs and spices that makes KFC's chicken distinctive. These intangible assets can be worth billions.
Billions, literally.
Literally. But a big warning here. Many countries are notorious for violating IP rights. If you're doing business internationally, you should always consult an attorney specializing in international IP law to safeguard your assets. Don't assume your U.S. protections automatically apply everywhere.
Good advice. So, how is intellectual property broken down? What are the main types?
Great question. Intellectual property is broadly divided into 4 distinct types, each protecting different kinds of innovation and creativity. First, we have copyright.
Copyright, okay, most people have heard of that.
Right. This protects original works of authorship, things like literary works, musical compositions, dramatic performances, pictorial or graphic designs, motion pictures, sound recordings, and even architectural works.
What about software? That's a big one for us.
Crucially, for computer software, copyright protects the expression of the software. That means the actual source code someone wrote, or the graphical user interface, the GUI, that you interact with.
The look and feel, the code itself.
Exactly.
Yeah.
But, and this is a key distinction, it does not protect the underlying idea, the functionality, or the methods of operation.
So if someone writes a new word processor program, they own the specific code they wrote, but not the concept of a word processor itself. That's a crucial distinction.
That's precisely it. You've nailed the core concept. To secure a copyright formally, there's a procedure. You send copies of the protected work along with a registration fee to the U.S. Copyright Office.
Do you have to register it?
Well, copyright technically exists from the moment the work is created in a tangible form. However, official registration provides strong legal proof of ownership and is generally required before you can sue for infringement and seek certain types of damages in court.
Okay, so registration gives you stronger legal footing. Who owns it? The creator.
Ownership typically defaults to the creator, yes. Unless, and this is common in employment, it's a work for hire. That means it was created by an employee as part of their job duties, in which case the employer usually owns the copyright.
Makes sense that the company paid for it to be created. How long does copyright last?
It lasts quite a while.
Where?
For works created by an individual author, it's typically the author's life plus 70 years. For a work for hire, or anonymous or pseudonymous works, it's 95 years from the date of publication, or 120 years from the date of creation, whichever expires first.
Wow, that's a long time.
It is. So copyright is like owning the sheet music, the script, or the complete blueprint of a creative work. You can't copy or perform it without permission. For software, it's like owning the exact unique code someone wrote, not the general concept of a search engine.
And this leads directly to a significant piece of legislation related to digital content, especially preventing copying, right?
It does, very directly. This brings us to the Digital Millennium Copyright Act, the DMCA of 1998.
DMCA, heard that one too. What's its main goal?
The DMCA's main provision, the one most people encounter, prohibits attempts to circumvent copyright protection mechanisms. Think about the copy protection technologies found on CDs, DVDs, or built into streaming services to prevent unauthorized copying or access.
So breaking the copy protection is illegal.
Yes, under the DMCA. Penalties for violating this can be severe, potentially up to $1 million fine and 10 years in prison for criminal violations.
Wow. What about ISPs? Are they liable if users share copyrighted stuff?
That's another critical part of the DMCA. The safe harbor provision for internet service providers, ISPs, and other online service providers like YouTube or social media platforms. An ISP can generally avoid liability for their users' infringing actions if certain conditions are met.
What conditions?
These include things like the transmission being initiated by a user, not the provider not modifying the content in transit, and most importantly, the provider promptly removing or disabling access to infringing material upon receiving a proper notification, a takedown notice from the copyright holder.
The famous DMCA takedown notice.
That's the one. So the DMCA is like putting a do not copy stamp on digital content and making it illegal to build a device or software specifically designed to bypass that stamp. It also provides that crucial safe harbor for ISPs, meaning they're not held liable if their users copy illegally, as long as the ISP cooperates by swiftly taking down infringing content when notified.
Okay, that clarifies the DMCA. Next up in IP, we have trademarks. How do these differ from copyrights? What do they protect?
Trademarks protect different things entirely. They protect words, slogans, logos, sounds, even colors. Sometimes anything used to identify a company, its products or services in the marketplace. Their primary purpose is to prevent marketplace confusion.
So consumers know who made what.
Exactly. It ensures consumers know who produced a particular good or service. Think of the distinctive branding of a popular fast food chain's logo, like the golden arches, or the specific shape of a famous soda bottle. A trademark instantly tells you who made something.
How do you get a trademark?
You register a trademark with the U.S. Patent and Trademark Office, the USPTO. This requires a comprehensive search beforehand to ensure your proposed mark doesn't already exist or isn't confusingly similar to an existing mark for related goods or services.
Can you register it before you use it?
Yes, you can actually apply for an intent to use trademark before you start using it commercially. This reserves your right to the mark while you prepare to launch.
Are there rules about what can be a trademark?
Yes, there are. Trademarks can't be overly descriptive or generic for the goods or services they represent. For example, you couldn't trademark Mike's Software Company for software because that just describes what it is, doesn't uniquely identify the source. It needs to be distinctive.
How long do trademarks last? Forever.
Potentially, yes, unlike patents or copyrights. Once registered, they last for an initial 10-year period, but they are renewable every 10 years, theoretically in perpetuity, as long as the mark is actively being used in commerce and the renewal fees are paid.
Interesting. Okay, then we have patents. These seem to protect the actual invention itself, how it works.
Exactly. Utility patents protect the intellectual property rights of inventors for new inventions, how something works or is made. They grant the inventor exclusive rights to use, make, or sell their invention for a set period, typically 20 years from the date of the initial patent application filing.
Exclusive rights for 20 years.
Well,
What does it take to get a patent? What are the requirements?
for an invention to be patentable, it must meet three main requirements. First, it has to be new, meaning it hasn't been publicly known, used, sold, or patented before.
Mm-hmm.
Second, it must be useful, providing some tangible benefit or utility. And third, critically, it must be non-obvious.
Non-obvious. What does that mean exactly?
It means the invention wouldn't be readily apparent or obvious to someone with ordinary skill in the technical field related to the invention at the time the invention was made. It has to represent a genuine inventive step.
Can you give an example?
Sure. You probably couldn't patent a simple drinking cup designed to collect rainwater, as that's a fairly obvious concept. However, you might be able to patent a specially designed cup that uses a unique, non-obvious mechanism to optimize rainwater collection while minimizing evaporation or filtering the water in a novel way.
Ah, okay. The specific how needs to be inventive.
Precisely. So a patent is like owning the unique blueprint for a brand new invention. And for that 20-year period, nobody else can build, sell, or use that exact invention without your permission.
Now, there's been some debate, hasn't there, about how patents apply specifically to software. It seems like a tricky area.
There absolutely has been, and it's frankly an ongoing area of contention and legal evolution. Some software logic or processes seem to qualify more for copyright protection, protecting the specific code written. But certain algorithms, especially foundational ones like the cryptographic algorithms RSA and Diffie-Hellman, have received patent protection in the past.
Which led to...
Well, this has even led to issues with so-called patent trolls entities, often non-practicing entities, that primarily exist to acquire patents, sometimes broad or arguably weak ones, and then aggressively enforce them against companies actually making products, often leading to costly legal disputes that some argue stifle innovation.
Right, the patent troll issue. Are there other types of patents besides utility patents?
Yes, beyond utility patents, there are also design patents, which protect the ornamental or aesthetic appearance of an invention, how it looks, not how it works, for 15 years from the date of grant. And there are also plant patents, which cover new, distinct, invented or discovered varieties of plants that could be asexually reproduced.
Okay. Finally, for IP, we have trade secrets. These feel like the most precarious form of IP protection, maybe the riskiest.
They are in a way because their protection relies entirely on secrecy. A trade secret is absolutely critical business information that provides a competitive edge and, if disclosed, would cause significant damage to the company.
Like the famous examples.
Exactly. The classic examples are indeed the Coca-Cola recipe or KFC's secret blend of 11 herbs and spices. The key to a trade secret is that it must be actively kept secret by the company.
What does actively kept secret involve?
It means implementing rigorous measures. Things like requiring non-disclosure agreements, NDAs for anyone who needs access to it, limiting physical and digital access on a need-to-know basis, and having strong security controls, both technical and procedural, in place to prevent unauthorized disclosure.
So no government registration.
Correct. Unlike patents or copyrights, there's no government registration process for trade secrets. Their protection lasts only as long as they effectively remain secret. If the secret gets out legitimately, or if someone independently develops the same information, the protection is lost.
So it's a high-stakes game of keeping quiet.
It really is. A trade secret is like your grandma's incredibly valuable, unique family cookie recipe. Its value relies entirely on you diligently keeping it secret and protected through your own continuous efforts.
And to protect these vital secrets, especially from theft, Congress passed specific legislation, right? Because losing them could be devastating.
Yes, exactly. To address the growing threat of industrial and economic espionage, Congress passed the Economic Espionage Act of 1996. This law makes stealing trade secrets a serious federal crime, recognizing the immense economic damage it can cause not just to companies, but potentially to national security as well.
What are the penalties like under this act?
The penalties are severe, reflecting the seriousness of the crime. For individuals found guilty of stealing trade secrets with the intention of benefiting a foreign government or agent, the fines can be up to $500,000, and imprisonment for up to 15 years.
Wow, 15 years. And if it's not for a foreign government?
For other circumstances, like stealing for a competitor or personal gain, it's still very serious. Potentially up to $5 million in fines for the organization and 10 years in prison for individuals. Organizations found guilty face even higher potential fines, sometimes up to $10 million or more.
So huge deterrence.
Hopefully. This act is like saying, not only is it a crime to steal the cookie recipe, but if you're stealing it for a foreign government, the penalties are even more severe due to the national economic and security implications. And more recently, the Defend Trade Secrets Act of 2016 added a civil right of action.
Meaning companies can sue.
Yes. It allows companies to file a civil lawsuit in federal court if their trade secrets are misappropriated, providing another important avenue for recourse and recovery beyond criminal prosecution.
Okay, that covers the main types of IP. Now here's where it gets truly interesting for anyone who uses a computer, which is, well, pretty much all of us. Software licensing.
Ah, the ELA nobody reads.
Exactly. When you acquire software, you're not typically buying the software itself in the traditional sense of ownership, right? You're often getting a detailed agreement on how you can actually use it.
That's absolutely right. The industry has evolved dramatically, and with it, the complexities surrounding how we license software have just multiplied. It's a critical area for cybersecurity professionals because these licenses dictate usage rights, responsibilities, and sometimes even specific security obligations.
So what are the common types of licenses we might encounter?
There are several common types, each with different implications. First, you have perpetual licenses. These are perhaps the most traditional model. You pay a one-time fee, and you get indefinite use of that specific version of the software.
Like buying a CD back in the day.
Exactly. It's like buying a house outright. You own it, or at least the right to use it, forever. However, updates to new versions or ongoing technical support might require additional payments or separate service contracts.
Okay. And the alternative that's become so common?
That would be subscription licenses. These have become incredibly common, especially with cloud-based services and software as a service, or SaaS. These involve a recurring fee, usually monthly or annually.
Pay as you go.
Pretty much. The license is time-bound, lasting only as long as you keep paying the subscription fee. The upside is they typically include updates, new features, and technical support as part of the subscription price. It's much like leasing a car where maintenance is often included in the monthly payment.
And what about something like Linux or other community-driven projects that are often freely available? Where do they fit?
That falls under the umbrella of open source licenses. Software distributed under an open source license, like the well-known GNU General Public License, the GPL, or the more permissive MIT license, is typically free to use, modify, and distribute.
Free as in freedom, and often free as in beer.
Often both, yes. The underlying source code is made publicly available, which encourages collaboration, transparency, and community development. However, there are often specific conditions attached that govern how you can use, modify, and distribute it. For example, some licenses, like the GPL, require you to also make your modifications open source if you distribute software based on it.
Okay, so free comes with conditions sometimes. What about freeware? Is that the same?
Not quite. Freeware is also software that's free to use, but it usually comes with more restrictions on usage or features. And crucially, you typically don't get access to the underlying source code like you do with true open source software. The developer retains full control.
Got it. What about big companies? Do they use these individual licenses?
Often not for large deployments. For large organizations, enterprise license agreements, or ELAS, are very common. These are comprehensive, often complex agreements that allow for software deployment throughout the entire organization, usually based on the number of users, devices, or sometimes processing power. They typically come at a discounted volume price compared to individual licenses and simplified license management, but they often involve significant upfront costs and commitments.
And for individual users installing software, what are those agreements we click through, the ones nobody reads?
Uh-huh. Yes, those are the end-user license agreements, or EULAS. They define the specific rights and restrictions that apply when you, the end user, use the software. They're usually presented during the installation or initial setup process, and by clicking I agree, you are legally binding yourself to their terms, whether you've read them or not.
Good reminder. Any other common types?
A couple more worth mentioning. Concurrent use licenses permit a specific limited number of users to access the software at the same time. Once that limit is reached, additional users have to wait until a license becomes available. Think of library seats.
Okay, limited simultaneous users?
Right. In contrast, named user licenses are tied to specific login credentials or individual users. They ensure only designated individuals can access the software, regardless of how many people are using it concurrently. It's licensed per person.
And with everything moving to the cloud, surely there are specific agreements there.
Absolutely. Cloud services license agreements, often for software as a service, SaaS products, are agreements for software accessed entirely via the internet. You don't install it locally. Users typically affirm their acceptance before accessing the service, often through a click-through agreement or maybe flash legal information on the screen during sign-up. It's crucial to understand that with SaaS, you're essentially renting access, not owning the software itself.
So lots of different models.
Definitely. In broad strokes, software licenses are like different ways to interact with a car. A perpetual license is like buying a car outright, but maybe paying extra for repairs later. A subscription is like leasing, you pay monthly and get maintenance included. Open source is like a car design blueprint shared freely, allowing anyone to build and modify it, while freeware is like getting a free rideshare where you don't own the car, but you get to use it for free, perhaps with limitations.
That's a helpful set of analogies. Now, beyond how software is licensed for use domestically, there are important federal regulations that control how sensitive technology, like high-performance computers and especially encryption software, can be moved across national borders. These are known as import-export controls.
Right. Managing what tech goes where.
Exactly. Historically, especially during the Cold War, this was primarily about preventing adversaries from acquiring advanced military technology. Now, while that's definitely still a focus, the scope has expanded significantly to include the transborder data flow of new technologies and also things like personally identifiable information, PII.
That's a key distinction. It's not just about hardware anymore. It used to be incredibly difficult to export high-performance computers and particularly strong encryption software from the United States, except maybe to a handful of closely allied nations.
Encryption was treated almost like munitions, wasn't it?
It effectively was, yes. The controls in exporting encryption software were historically very severe, sometimes rendering it virtually impossible for widespread commercial use internationally. However, recent changes in federal policy, largely due to intense lobbying from the software and tech industry.
Ah, lobbying.
Indeed. That lobbying has led to a relaxation of many of these restrictions, providing for much more open commerce, particularly for widely available mass-market encryption products. Still, the core principle remains. These are like strict customs rules for highly sensitive goods. Think of trying to send a military-grade drone or a top-secret encryption device across international borders without the proper clearance.
So, what are the specific key regulations governing these controls today? What do people need to know?
There are two primary sets of federal regulations you should generally be aware of. First, the International Traffic in Arms Regulations, known as ITAR.
ITAR.
ITAR controls the manufacture, export, and import of items specifically designated as military and defense articles, including related technical data and services. These items are meticulously listed on the United States Munitions List, or USML.
So ITAR is strictly for military stuff.
Primarily, yes. Secondly, you have the Export Administration Regulations, or EAR.
EAR, how is that different?
EAR covers a much broader range of commercial and dual-use items. These are items designed for commercial use, but which could also have military or proliferation applications. This includes many cybersecurity products, advanced computing hardware, and certain types of encryption. These items are found on the Commerce Control List, or CCL, which is maintained by the U.S. Department of Commerce's Bureau of Industry and Security, or BIS.
BIS handles the ER list. And what about specific countries? I imagine not all nations are treated equally under these rules. There must be restrictions on where things can go.
You're absolutely right. Certain countries of concern, nations subject to sanctions, embargoes, or specific foreign policy controls, require prior approval, a license for the export of control items, especially high-performance systems, from BIS. These lists change, but historically include countries like Cuba, Iran, North Korea, and Syria, among others, based on various national security and foreign policy considerations.
So you always need to check the destination country.
Always. It's critical to understand that ITAR is generally for things like stealth fighter jets or advanced missile technology, whereas EAR is for potentially sensitive but more common items, like a high-tech supercomputer or advanced encryption software that has commercial applications but could be misused. Both have strict rules about where they can go and under what conditions.
And the takeaway?
A big warning here. This is a highly specialized and complex legal area. If you or your organization encounter any issues related to import-export controls, especially concerning encryption or control technologies, always seek expert legal advice from someone specializing in trade compliance. Mistakes can lead to severe penalties, including hefty fines and even criminal charges.
Definitely not an area for guesswork. Okay, let's pivot now to a topic that touches absolutely everyone, from individuals to global corporations, and is currently one of the most hotly debated subjects globally.
Privacy laws.
Privacy, a minefield in itself.
It really is. And it's fascinating because in the U.S., there isn't an explicit, single, overarching constitutional guarantee of privacy like in some other countries. However, the Fourth Amendment to the Constitution is often cited as the foundational basis for privacy rights.
Right, the Search and Seizure Amendment. Exactly. It protects individuals against unreasonable searches and seizures by the government and requires warrants based on probable cause. Over time, courts have interpreted and expanded this principle to include protections against government wiretapping and other invasions of digital privacy, creating a sort of implied right to privacy from government intrusion in certain contexts.
Yeah.
So the Fourth Amendment is like the don't come into my house without a proper warrant rule.
And it's been judicially extended to some degree to protect our digital homes and communications, at least from government overreach.
Okay, that's crucial legal background.
Yeah.
Moving to specific U.S. privacy laws enacted by Congress, one of the earliest and most significant pieces of privacy legislation is the Privacy Act of 1974.
Right, goes way back. What's its focus?
Its focus is primarily on restricting how the federal government handles personally identifiable information, or PII, about individuals.
Only the federal government.
Yes, that's key. It mandates that federal agencies maintain only necessary records about individuals, destroy unnecessary ones, and importantly, allow individuals to access and request amendments to their own records held by the agency.
So transparency and control over your government files.
Exactly. It also significantly restricts the disclosure of PII by federal agencies to third parties without the individual's consent, though it does include important exceptions for things like law enforcement purposes, national security, or routine uses within the agency.
But again, applies only to federal government agencies, not private companies.
Correct. It's like your personal file cabinet at a federal agency like the Social Security Administration. The Privacy Act gives you the right to see what's in it, correct mistakes, and generally ensures the agency doesn't share it inappropriately without your permission.
So it's a common misconception that the Privacy Act of 1974 applies broadly to private sector organizations. That's important to clarify.
Absolutely. That's a very common point of confusion. It does not generally apply to private businesses. Now, for electronic communications specifically, we have the Electronic Communications Privacy Act, or ECPA, passed in 1986.
ECPA, what did that do?
This act made it a federal crime to intentionally invade electronic privacy. It significantly broadened the older federal Wiretap Act to protect electronic communications like email and voicemail, as well as traditional phone calls. It generally prohibits the intentional interception or unauthorized access of wire oral or electronic communications while in transit or in storage.
So protecting emails and voicemails like physical mail.
Essentially, yes. Penalties for violations can include fines, even imprisonment, for example, up to 5 years in prison for illegally monitoring mobile phone conversations without proper authorization or consent. The ECPA is like extending the legal protection of your sealed physical mail and private phone calls to your digital equivalents, your emails and voicemails.
Okay. But wasn't there a law requiring phone companies to help law enforcement with wiretaps? Seems contradictory.
Good point. Building on ECPA, the Communications Assistance for Law Enforcement Act, CALEA of 1994, amended ECPA. CALEA essentially requires telecommunications carriers and manufacturers of telecommunications equipment to design their systems and networks in a way that makes lawful wiretaps technically possible for law enforcement agencies, provided they have a valid court order or other lawful authorization.
So CLA mandates technical capability for lawful interception.
Right. It's like requiring all phone companies and network equipment makers to build a standardized, secure backdoor or interface into their systems. So if law enforcement gets a legitimate warrant, they can actually execute the wiretap effectively. It doesn't grant new surveillance powers, but ensures the technical means exist when surveillance is legally authorized.
We also briefly touched on the Economic Espionage Act of 1996 earlier when discussing trade secrets. While primarily about protecting proprietary business information, it also has a privacy aspect, right? Because stealing that information often involves stealing sensitive data about individuals or private business operations.
Yes, definitely an overlap there. Now, for a sector as critical and intensely sensitive as healthcare, there's a huge piece of legislation. The Health Insurance Portability and Accountability Act, HIPAA of 1996.
HIPAA. Everyone's heard of HIPAA forms.
Exactly. HIPAA established strict nationwide security and privacy standards for protected health information, or PHI. This applies to covered entities like hospitals, physicians, health plans, insurance companies, and health maintenance organizations, HMOs, as well as their business associates.
PHI, that's the key term. What does HIPAA demand?
It meticulously defines individual rights regarding their medical records, including the right to access their own PHI, request corrections, receive an accounting of disclosures, and restricts certain uses and disclosures. It mandates administrative, physical, and technical safeguards to protect the confidentiality, integrity, and availability of electronic PHI.
And the penalties for violating HIPAA?
They can be severe, ranging from fines to potential criminal charges for knowing violations. IPI regulations are incredibly complex, and compliance is a major focus in the healthcare industry. If you work in or with healthcare, seeking expert legal advice on HIPAA is absolutely essential. HIPAA is like a heavily fortified vault for your medical records. It dictates precisely how your doctor, hospital, and insurance company must protect your most sensitive health information, ensuring it's only accessed and shared under very specific controlled conditions.
And how did HIPAA evolve to address newer challenges, particularly with the rise of electronic health records and digital data sharing? That must have required updates.
It certainly did. That's where the Health Information Technology for Economic and Clinical Health Act, the HITECH Act of 2009 comes in. HITECH significantly amended HIPAA.
HITECH amended HIPAA.
Yeah, it introduced new, often stricter, privacy and security requirements specifically addressing electronic health information and promoting the adoption of secure electronic health records. These requirements were further implemented and strengthened by the HIPAA Omnibus Rule in 2013.
What were some key changes under HITECH?
A really significant change was making business associates, or BAs, remember. Those are external contractors or vendors who handle PHI on behalf of a covered entity, like a billing company or a cloud storage provider, directly subject to HIPAA enforcement and penalties.
So the contractors became directly liable too.
Exactly. Previously, the primary covered entity, like the hospital, was mainly liable for their contractor's breaches. Now the BA itself is directly accountable under HIPAA. HITECH also introduced the nationwide data breach notification rule for healthcare.
Breach notification became mandatory under federal law for health data.
Yes. It created a federal mandate for healthcare organizations and their business associates to notify affected individuals, the Health and Human Services Secretary, HHS, and sometimes the media if a breach of unsecured PHI affects more than 500 individuals. Notifications generally must occur without unreasonable delay and no later than 60 days after discovering the breach.
So, HITECH significantly strengthened HIPAA, making the vault for medical records even more secure, holding contractors directly accountable, and mandating prompt public notification if that vault is ever broken into.
Precisely. It added more teeth and transparency to hypo.
And this leads us naturally to broader data breach notification laws beyond just healthcare. I know California was a real pioneer here, wasn't it? Setting the trend.
Indeed. California's Senate Bill 1386, SB 1386, passed way back in 2002, was truly groundbreaking. It was the first statewide requirement in the U.S. for organizations to notify individuals if they're unencrypted. Personally identifiable information, PII, was potentially acquired in a security breach.
What kind of PII did it cover?
It covered specific data elements like social security numbers, driver's license numbers, state ID numbers, and financial account numbers like credit or debit card numbers in combination with any required security code or password. This act spurred a wave of similar legislation across the country.
So California started it, and other states followed.
Exactly. Now, many, if not most, other states have since passed their own comprehensive data breach notification laws, often with varying definitions of PII, different notification timelines, and specific requirements for reporting to state attorneys general. This creates a complex compliance web for organizations operating nationwide. They have to track and comply with potentially dozens of different state breach laws.
A compliance nightmare for national companies, I imagine. What about specific protections for children online? That seems crucial.
Absolutely critical. For that, we turn to the Children's Online Privacy Protection Act, COPPA, of 1998.
COPPA, what does it require?
This act places strict demands on operators of websites and online services that are directed towards children under 13 or that knowingly collect personal information from children under 13.
What kind of demands?
It requires them to provide clear and comprehensive privacy notices explaining their data practices. Crucially, it requires them to obtain verifiable parental consent before collecting, using, or disclosing any personal information from children under 13. It also mandates giving parents the right to review the personal information collected from their child and the ability to request its deletion.
So parents must give permission first.
Yes, verifiable parental consent is the cornerstone. COPPA is like setting up a special protected kids zone online where companies need explicit parental permission slips before they can collect any personal information from young children, ensuring their digital safety and privacy are prioritized from a young age. Violations are enforced by the Federal Trade Commission, the FTC, and can result in significant penalties.
Okay, very important for websites kids might use. Now, for financial data, which is obviously extremely sensitive for adults, what's the main law in place to protect our information there?
That would primarily be the Gramm-Leach-Bliley Act, or GLBA, of 1999, sometimes called the Financial Services Modernization Act.
GLBA. Who does it apply to?
It applies to financial institutions, a term defined broadly to include not just banks, but also securities firms, insurance companies, credit providers, tax preparers, and others significantly engaged in financial activities.
What does it require them to do regarding privacy?
GLBA has several key components, including the Financial Privacy Rule and the Safeguards Rule. The Privacy Rule requires financial institutions to provide customers with clear notices about their information sharing practices. Critically, it must explain what information they collect, who they share it with, and how they protect it. It also requires them to give customers the right to opt out of having their non-public personal information shared with certain non-affiliated third parties.
So transparency and an opt-out right.
Exactly. The Safeguards Rule requires financial institutions to develop, implement, and maintain a comprehensive written information security program containing administrative, technical, and physical safeguards appropriate to the size and complexity of the institution and the sensitivity of the customer information it handles.
Mandating a security program.
Yes. So GLBA is about how your bank, insurance company, or credit provider can share your financial information, particularly within their corporate family of companies and with outside parties. It mandates transparency through privacy notices and gives you some control via opt-out rights, while also requiring them to actively protect your data.
Okay. Then, in the wake of the 9/11 terrorist attacks, we saw the very controversial USA Patriot Act of 2001. How did this impact privacy and cybersecurity from a legal perspective?
The Uniting and Strengthening America by Providing Appropriate Tools Required to Intercept and Obstruct Terrorism Act, yes, that's the full name, hence USAPATRIOT Act, was passed swiftly in direct response to the September 11th attacks. It significantly broadened the powers of U.S. law enforcement and intelligence agencies, primarily in the name of preventing future terrorist acts and enhancing national security.
How did it broaden powers specifically related to surveillance and data?
It expanded government authority to conduct surveillance of communications. For example, it eased requirements for obtaining wiretapping authorizations under the Foreign Intelligence Surveillance Act, FISA. It authorized roving wiretaps that follow a specific surveillance target rather than just a specific phone line or device. It also lowered the threshold for the government, particularly the FBI, to obtain certain types of records from third parties like banks or communication providers using national security letters, NSLs, or subpoenas, often without requiring traditional probable cause warrants in certain national security contexts.
So easier access to communication data and business records for intelligence purposes.
In many cases, yes. It also allowed the government to obtain user activity data and subscriber information from internet service providers via subpoena with fewer hurdles than previously required in some investigations. Furthermore, it amended the CFAA, imposing more severe penalties for computer crimes deemed to be acts of terrorism or related to national security.
And what's the status of the Patriot Act now? I know parts were set to expire.
That's right. Some key surveillance provisions originally expired in 2015. However, many were later modified and restored by the USA FREDOM Act, Uniting and Strengthening America by Fulfilling Rights and Ensuring Effective Discipline Over Monitoring Act, in June 2015, which aimed to add some reforms and transparency requirements. Some provisions were renewed again in 2020, though debates about the balance between national security and civil liberties continue. The Patriot Act is essentially like giving law enforcement and intelligence agencies a broader set of keys and tools to access communication channels and data trails in times of perceived national security threats, allowing them to follow a suspect's digital footprint more easily, even across different services. But it definitely raised, and continues to raise, significant privacy and oversight concerns.
A very complex and debated piece of legislation. Now, in our increasingly interconnected world, data doesn't stay in one country. It's often stored in data centers across national borders. How does U.S. law enforcement legally access electronic data when it's held by a U.S. company but stored physically overseas? That used to be legally ambiguous.
That's precisely the issue addressed by a more recent law. The Clarifying Lawful Overseas Use of Data Act, or CLOUD Act, passed in 2018.
The Cloud Act, what does it do?
Its primary purpose is to establish clearer legal procedures for accessing electronic data held by U.S.-based technology companies, regardless of where that data is physically stored globally. It explicitly confirms that U.S. law enforcement can use domestic warrants and subpoenas to compel U.S.-based service providers, like email providers or cloud storage companies, to disclose requested electronic data, even if that data is stored on servers located outside the United States.
So it asserts U.S. jurisdiction over data held by U.S. companies wherever it's stored.
Essentially, yes, regarding legal process. It aimed to resolve legal challenges and uncertainty that arose previously. Additionally, the Cloud Act authorizes the U.S. government to enter into bilateral executive agreements with specific foreign partner countries that meet certain standards for privacy and civil liberties protections. These agreements would allow for reciprocal data access rights in criminal investigations, potentially speeding up cross-border data requests between trusted partners by bypassing slower traditional mutual legal assistance treaties, MLS.
Okay, so it clarifies U.S. reach and sets up potential faster tracks with partner countries.
Exactly. The Cloud Act is like building a specific digital bridge for U.S. law enforcement to access data controlled by U.S. companies globally using U.S. legal process, while also creating a framework for reciprocal bridges with allied nations under certain rules for criminal investigations, acknowledging the global nature of data storage and the need for timely access in investigations.
Got it. Now, shifting focus to a specific sector, education. What law protects student privacy? We hear about FERPA quite often in schools and universities.
Yes, for student privacy, the primary federal law is the Family Educational Rights and Privacy Act, or FERPA.
FERPA. What are its key provisions?
FERPA is a federal law that focuses specifically on protecting the privacy of student education records in educational institutions that receive federal funding. It grants eligible students, generally students 18 or older or attending post-secondary institutions, or their parents certain rights concerning these records.
What rights?
Key rights include the right to inspect and review the student's education records maintained by the school, and the right to request corrections if they believe the records contain inaccurate or misleading information. Most importantly, FERPA generally requires schools to obtain written consent from the parent or eligible student before disclosing personally identifiable information from the student's education records to third parties.
So consent is needed to share student records.
Generally, yes. Though there are significant exceptions, for instance, disclosures to school officials with legitimate educational interests, transfers to another school where the student seeks to enroll, disclosures for financial aid purposes, certain judicial orders, and disclosures of directory information like name, address, phone number, if the school has given public notice and allowed parent students to opt out.
Okay, so FERPA acts like the privacy rules for your official school records, giving students or their parents control over who sees sensitive academic and personal information held by the school, ensuring that details about education remain generally confidential.
That's a good summary. And finally, to combat a truly pervasive and damaging modern crime, what specific federal legislation tackles identity theft head on?
To address that specifically, Congress passed the Identity Theft and Assumption Deterrence Act, or ITADA, back in 1998. What makes it significant?
This law is significant because it formally established identity theft as a distinct federal crime. Crucially, it defined the crime as knowingly transferring or using, without lawful authority, a means of identification of another person with the intent to commit or aid or abet any unlawful activity. It recognized the victim as the person whose identity was stolen, not just the financial institutions or businesses that might have been defrauded.
So it made the individual whose identity was stolen the direct victim under federal law.
Exactly. And it carries severe criminal penalties, including potential imprisonment for up to 15 years, depending on the circumstances, substantial fines, and asset forfeiture for those convicted of aggravated identity theft. The Aitatata is really about fighting the crime of someone literally stealing your digital mask, your personal identifying information, and using it to commit fraud, obtain benefits, or engage in other crimes in your name.
Okay, a direct attack on identity thieves. Now let's consider a real-world scenario that often sparks considerable debate and can be a legal minefield for employers. Privacy in the workplace.
Ah, yes. Using work computers for personal stuff.
Exactly. We've heard stories, maybe even experienced situations where employees are disciplined or fired for things like abusing internet privileges or sending personal emails on company equipment. And sometimes they're shocked, believing the company violated their privacy rights. What's the actual legal reality here in the U.S.?
This is a critical area for cybersecurity professionals, HR departments, and employers alike. Generally speaking, the U.S. court system has largely and consistently upheld the principle that employees typically have very little or no reasonable expectation of privacy when using employer-owned equipment, networks, or systems.
No reasonable expectation of privacy. That sounds pretty definitive.
It generally is in most private sector workplaces. The principle extends to emails sent or received on company accounts, internet browsing history on work computers, files stored on company servers or devices, and sometimes even keystrokes or screen activity. The legal reasoning often compares it to the difference between sending a sealed personal letter versus writing on a company memo pad left on your desk. You expect privacy with the letter, but the memo pad belongs to the company and is part of the work environment.
So the analogy is the desk, the computer on it, the network you connect to, they're generally owned by the company, not you personally.
That's the common legal perspective. Therefore, the employer generally has the right to monitor communications and activities conducted using their resources, often for legitimate business purposes like ensuring productivity, enforcing policies, investigating misconduct, or protecting security. This is quite different from your personal email or phone at home, where you have a much stronger expectation of privacy, especially from government intrusion under the Fourth Amendment.
That's a stark but really important distinction for employees to understand. So, given that employers generally can monitor, what measures should they take to ensure their monitoring is legal, transparent, and less likely to lead to disputes or morale issues?
That's key, doing it properly. To ensure employers can monitor legally and manage employee expectations effectively, several common measures are highly recommended. First, having explicit clauses in employment contracts or employee handbooks stating clearly that there is no expectation of privacy when using company resources and that monitoring may occur.
Get it in writing up front.
Absolutely. Second, implementing comprehensive written acceptable use policies, AUPs, that detail what constitutes permissible and prohibited use of company systems and explicitly state the company's right to monitor. Having employees sign acknowledgments of these policies is crucial.
Clear rules and acknowledgement.
Right. Many organizations also use prominent logon banners that appear when users log into their computers or networks. These banners typically warn users that all communications and activities on company systems are subject to monitoring and are not private. Consent is often inferred from clicking through the banner to proceed. These measures help establish consent and manage expectations, reducing the surprise factor.
So transparency is key.
Hmm.
Any final advice for employers?
Definitely. While these measures are common, laws can vary slightly by state, and specific situations, like monitoring personal devices used for work under BYOD policies or union environments, can add complexity. Therefore, it's always advisable for organizations to consult with experienced legal counsel before implementing or significantly changing any employee monitoring programs or technologies, just to ensure compliance with all applicable federal and state laws and to minimize legal risks.
Okay, sound advice. Now let's unpack this for the global stage. We've talked a lot about U.S. laws, but privacy and data protection are huge international issues. Beyond the U.S., other regions have developed their own robust privacy frameworks, and these often have a significant impact on multinational companies, regardless of where they are physically headquartered.
Absolutely. If you do business internationally, you can't just focus on U.S. law. And leading the way, really setting a global benchmark in many respects, is the European Union General Data Protection Regulation, the GDPR.
GDPR, that one definitely made waves globally when it came into effect in 2016.
It really did. GDPR is a single, harmonized data protection law that applies across all 27 EU member states, plus the European Economic Area countries. It replaced an older, more fragmented directive from 1995.
What makes GDPR so significant and far-reaching? Why did U.S. companies have to pay so much attention?
Primarily because of its incredibly broad territorial scope. GDPR applies not only to organizations based in the EU, but also to any organization anywhere in the world that processes the personal data of EU residents in connection with offering them goods or services or monitoring their behavior, like online tracking. So its impact is truly global, affecting countless U.S. and other non-EU companies.
Right, that extraterritorial reach is key. What are some of its core principles or provisions?
GDPR is built on several core principles. It demands lawfulness, fairness, and transparency in all data processing activities. It enshrines the principle of purpose limitation, meaning data can generally only be collected for specified, explicit, and legitimate purposes, and not further processed in incompatible ways. It mandates data minimization, requiring organizations to collect only the data that is adequate, relevant, and limited to what is necessary for the purpose.
So collect less, be clear why. What else?
Accuracy is crucial data, must be accurate and kept up to date. Storage limitation ensures data isn't kept in an identifiable form for longer than necessary, which embodies the famous right to be forgotten or right to erasure under certain conditions. Integrity and confidentiality must be ensured through appropriate technical and organizational security measures. And finally, the principle of accountability requires data controllers, the organizations determining the purposes and means of processing, to be responsible for and demonstrate compliance with all these principles.
Demonstrate compliance, that's a big burden.
It is. And I know the GDPR's strict rules on transferring personal data outside the EU are a significant concern and a complex area for many organizations. How do companies legally transfer EU resident data to countries like the US, which the EU doesn't automatically consider as having adequate data protection laws?
Indeed, cross-border data transfers are one of the most challenging aspects of GDPR compliance. To legally transfer personal information outside the EUEA to countries not deemed adequate by the European Commission, organizations typically need to rely on specific legal mechanisms or transfer tools approved under GDPR. What are the main options?
Two primary ones used frequently are standard contractual clauses, or SCCs. These are essentially pre-approved model contract clauses issued by the European Commission that the data exporter in the EU and the data importer outside the EU can incorporate into their agreements. These clauses contractually impose GDPR-level data protection obligations on the data importer.
Okay, standardized contracts. What's the other main one?
Another mechanism often used by multinational corporations for intergroup transfers is binding corporate rules, or BCRs. These are internal privacy policies and procedures governing data transfers between entities within the same corporate group. BCRs require a lengthy approval process by EU data protection authorities, but provide a comprehensive framework once approved.
SCCs and BCRs. Got it. What about the Privacy Shield? Didn't that used to be an option for U.S. companies?
It did. The EU's Privacy Shield framework was a popular mechanism allowing U.S. companies to self-certify compliance with EU data protection standards for transfers. However, it was invalidated in July 2020 by a landmark ruling from the Court of Justice of the European Union, known as the Schrems second case. The court found that U.S. surveillance laws did not adequately protect EU residents' data privacy rights.
So Privacy Shield is gone. What now?
Its invalidation created significant challenges. While SECs remain valid, the Schrems 230 ruling requires organizations using them to conduct case-by-case assessments, transfer impact assessments, or TIAs, to ensure the recipient country's laws don't undermine the protections offered by the SECs, potentially requiring supplementary measures. Meanwhile, the EU and US have been working on negotiating a new framework, the EU-US Data Privacy Framework, to replace Privacy Shield, but its long-term viability is still being assessed. GDPR overall acts like a powerful global privacy bodyguard for every EU citizen's personal data, no matter where that data travels or which company holds it, giving individuals strong, enforceable control and rights over their own information. A complex and evolving picture for international data flows. What about other major regions and their approaches to privacy? Are there similar comprehensive laws elsewhere?
Absolutely. The trend towards comprehensive data protection laws is global. For example, the Asia-Pacific Economic Cooperation, APEC, Forum has developed a voluntary cross-border privacy rules, CBPR, system. It's a framework aimed at promoting accountable cross-border information flow while maintaining robust privacy practices across its member economies based on a set of common principles.
In Canada.
In Canada, the main federal private sector privacy law is the Personal Information Protection and Electronic Documents Act, PIPEDA. PIPEDA applies to commercial businesses across Canada, unless a province has substantially similar legislation, like in Quebec, BC, and Alberta. It governs how organizations collect, use, and disclose personal information in the course of commercial activities. What kind of information does PIPEDA consider personal?
It defines personal information quite broadly, covering a wide range of PII, from basic identifiers like name and address to more sensitive data including race, national or ethnic origin, religion, age, marital status, medical, education, or employment history, financial information, DNA, and even employee performance records in federally regulated sectors. PIPEDA is essentially Canada's version of a comprehensive data protection law for the private sector, focusing on consent, access rights, and accountability in commercial activities.
Okay. And what about in major economies like China and South Africa, which have their own unique legal and economic systems? Have they enacted similar laws?
Yes, they have, reflecting that global trend. China enacted its first comprehensive national data privacy standard, the Personal Information Protection Law, or PIPL, which came into effect in late 2021. It's quite analogous to the GDPR in its scope and many of its core principles. PIPL in China, what are its key aspects? Key aspects include mandating explicit and informed consent for most data processing activities, emphasizing the principle of collecting only the minimum necessary data for a specified purpose, granting individuals strong data subject rights like access, correction, deletion, implementing strict rules and requirements for transferring personal data outside of China, often requiring government approval or standard contracts, and imposing potentially very heavy penalties for noncompliance. PIPL represents China's significant step into comprehensive privacy regulation, creating a robust framework with principles similar to GDPR, especially around consent, data minimization, and international data transfer controls. And South Africa.
Similarly, South Africa fully implemented its Protection of Personal Information Act, POPIA, or PPI Act, in 2020. POPI largely mirrors GDPR principles and applies to both public and private bodies processing personal information within South Africa. What does PPI cover?
It includes core provisions around conditions for lawful processing, like consent, necessity, and legitimacy, requiring purpose specification, setting limits on further processing, ensuring information quality, mandating openness and transparency, requiring security safeguards, and providing for data subject participation rights. It also has specific rules for processing special personal information, like race or health, and children's information, regulates cross-border data transfers, requires notification of security breaches, and establishes an information regulator with significant enforcement powers and penalties for violations. POPIA is South Africa's comprehensive law echoing many of the strong privacy principles seen in GDPR, further illustrating this global movement towards stronger, more harmonized privacy regulations. It's clear that robust privacy regulation is a global concern now, and many U.S. states have also taken the initiative, not waiting for federal action, by passing their own comprehensive privacy laws, creating that patchwork we mentioned earlier. California's California Consumer Privacy Act, the CCPA of 2018, and later amended by the CPRA, is a particularly notable example, often considered to be modeled, at least in part, after the GDPR.
Yes. CCPA was groundbreaking in the U.S. context. It grants California consumers significant new rights over their personal information held by covered businesses.
What kind of rights does CCPA provide?
Key rights include the right to know what personal information a business collects about them, where they got it, why they collect it, and who they share it with. Consumers also have the right to request deletion of their personal information held by the business, similar to GDPR's right to be forgotten, though with more exceptions. They have the right to opt out of the sale or sharing, a term broadened under CPRA, of their personal information. And importantly, they have the right to exercise these privacy rights without facing discriminatory treatment or retaliation from the business. So, know, delete, opt out, and non-discrimination.
Those are the core pillars. The CCPA and similar laws subsequently passed in states like Virginia, Colorado, Connecticut, Utah, and others illustrates the growing fragmentation of privacy laws even within the United States, making compliance an increasingly complex endeavor for businesses operating nationwide or even just having customers in multiple states.
Okay, bringing all these diverse legal and regulatory frameworks together. U.S. federal laws, state laws, international laws like GDPR, industry standards. What does this all mean for organizations on a practical level? In such a complex, dynamic, and ever-expanding regulatory environment, compliance is absolutely paramount, isn't it?
It has to be. Organizations face this incredibly wide variety of laws, industry standards, and contractual obligations that dictate exactly how they must handle data, protect systems, and respond to incidents. So the big question is, how do organizations navigate this intricate web effectively to stay on the right side of the law, protect their valuable assets and reputation, and maintain customer trust?
It's a huge ongoing challenge requiring dedicated resources and expertise. But one prime example of a non-governmental yet absolutely critical compliance standard that impacts many businesses globally is the Payment Card Industry Data Security Standard, PCI DSS.
PCI DSS, we hear about that all the time with credit cards.
Yes, exactly. It's crucial to understand that PCI DSS is an industry standard. It's not a federal or state law enacted by a government. However, compliance is effectively mandatory because it's a contractual obligation for any entity that stores, processes, or transmits credit and debit card holder data.
How is it enforced if it's not a law?
It's strictly enforced through merchant agreements with the major payment card brands: Visa, MasterCard, American Express, Discover, JCB, and the banks that process their transactions, the acquirers. Failure to comply with PCI DSS can result in severe consequences imposed by the card brands, including substantial fines, increased transaction fees, potential loss of the ability to process card payments altogether, and significant reputational damage following a breach.
So the card brands enforce it contractually. What does PCI DSS actually require?
PCI DSS version 4.0, the latest major version, lays out 12 main requirements, which are further broken down into many detailed sub-requirements. These can be broadly grouped into key goals or categories, such as building and maintaining a secure network and systems, example, firewalls, secure configurations, protecting account data, example, encryption of stored data, masking displayed data, maintaining a vulnerability management program, example, patching, secure development, implementing strong access control measures, example, unique IDs, least privilege, multi-factor authentication, regularly monitoring and testing networks, example, logging, intrusion detection, penetration testing, and maintaining an information security policy that addresses security for all personnel.
It sounds incredibly comprehensive, like a detailed security blueprint specifically for card data.
It is exactly that. PCI DSS is like a strict mandatory security blueprint or checklist for any shop, online store, or service provider that handles payment card data. While not a government law, if you want to accept major credit or debit card payments, you must follow these detailed security rules.
Do companies just self-assess or are there audits?
It depends on the level of the merchant or service provider, based on their transaction volume. Larger entities typically must undergo rigorous annual on-site assessments conducted by independent qualified security assessors, QSAs. Smaller entities might be allowed to complete self-assessment questionnaires, SAQs, but often still require regular vulnerability scans by approved scanning vendors, ASVs. Compliance isn't a one-time thing. It requires ongoing effort and validation.
And a crucial warning here, it's not just for merchants, right? Who else needs to comply?
That's a critical point.
Mm-hmm.
Even entities that are not direct merchants selling goods or services to cardholders, but who store, process, or transmit credit card information on behalf of others, think shared hosting providers, payment gateways, managed service providers, must also fully comply with all relevant PCI DSS requirements. If they handle card data, they're in scope.
Okay, PCI DSS is a huge example of industry-driven compliance. Beyond industry standards like that, formal compliance audits are a key part of staying compliant with laws and regulations and demonstrating due diligence. What role do these play more broadly?
Compliance audits are essential verification mechanisms. They are regular, structured assessments, often conducted periodically by internal audit teams, independent external auditors, or sometimes directly by regulatory agencies. Their goal is to objectively ensure that an organization's information security controls, policies, and procedures are designed effectively, operating as intended, and aligned with various applicable laws, regulations, and standards.
Can you give an example related to a specific law?
Sure. Take the Sarbanes-Oxley Act, SOX, which we mentioned briefly. SOX is a U.S. federal law enacted in response to major corporate accounting scandals in the early 2000s. Section 404 of SOX specifically requires publicly traded organizations to establish and maintain adequate internal controls over their financial reporting processes. Critically, it mandates that companies retain independent external auditors to formally audit and attest to the effectiveness of these internal controls annually. The auditors report their findings to regulators and the public, aiming to prevent corporate accounting fraud and protect investors. IT controls are a huge part of SOX compliance because financial data relies heavily on IT systems. So SOX audits focus heavily on IT controls for financial systems.
They do. These formal audits, whether for SOX, HIPAA, FISMA, or other frameworks, often involve a significant number of internal and external stakeholders coordinating between IT and security teams, legal counsel, finance departments, business units, and the auditors themselves. Organizations are typically required to provide extensive evidence, undergo interviews, submit self-assessment reports, and facilitate rigorous testing by third-party auditors to independently demonstrate their compliance status.
So compliance audits are like regular independent inspections to ensure your building's safety plan, whether that's the federal security plan under FISMA, the patient privacy rules of HIPAA, or the financial reporting controls mandated by SOX are actually being followed consistently, are effective in practice, and meet the required standards documented by law or regulation. They provide assurance to management, regulators, and stakeholders.
Assurance and accountability. Okay, now here's where it gets really interesting, I think, for modern businesses, especially with the massive explosion of cloud computing and reliance on outsourced services, contracting and procurement.
The supply chain, the extended enterprise.
Exactly. With the increased use of cloud services, IS, PIS, SAFAs, and reliance on countless external vendors for everything from HR systems to data analytics, organizations are outsourcing more and more sensitive information storage, processing, and transmission. This means you're effectively extending trust, and by extension, your entire security posture and compliance obligations well beyond your own four walls.
That's a crucial point. It's no longer just about what you control directly within your own network. It's critically about who you choose to trust with your data and services and how you manage that relationship. Vendor risk management is huge now.
So what should cybersecurity professionals be doing here? How do you manage that risk?
Cybersecurity professionals must play a key role by conducting thorough security reviews and due diligence during both the initial vendor selection process and as part of ongoing vendor governance and contract management throughout the relationship lifecycle. When you're considering using a third-party vendor, especially one that will handle sensitive data or provide critical services, there are absolutely crucial due diligence questions you simply must ask and get satisfactory answers to.
Okay, give us some examples. What are the must-ask questions?
All right, for example, first, clearly define. What specific types of sensitive information will this vendor store, process, or transmit on your behalf? Is it the PII, PHI, payment card data, confidential intellectual property, or maybe critical operational data? Understanding the data involved defines the risk level.
Know the data first. Makes sense.
Second, what specific security controls does the vendor claim to have in place to protect your information? Don't just take their word for it. Can they provide concrete evidence of their effectiveness, such as recent certifications, like ISO 27001, attestations, like SOC2 Type 2 reports, or independent audit results?
Verify their controls. What about shared environments?
Good point. If it's a multi-tenant environment, like most cloud services, ask, how is your organization's information logically and perhaps physically segregated from that of their other clients? What controls prevent data commingling or unauthorized access between tenants?
Segregation is key in the cloud. What about encryption?
Definitely ask about encryption. If encryption is used for data at rest or in transit, what specific algorithms and protocols are employed? Are they current industry standards? And critically, how is encryption key management handled? Does the vendor manage the keys, or do you retain control, e.g. using customer-managed keys or BYOK bring your own key? Key management is often overlooked but vital.
Those are fundamental technical questions. But what about their own security posture and their reliance on other vendors, the deeper supply chain?
Exactly. You need to probe deeper. Ask, what types of independent security audits or penetration tests does the vendor regularly undergo? Can you access summaries or full copies of those reports, perhaps under NDA, to verify their security posture independently?
Can we see their homework?
Essentially, yes.
Yeah.
And a critical question often missed. Does the vendor rely on other third parties, sub-processors or fourth parties, for critical parts of the services they provide to you that involve your data? If so, how do they manage their vendor security? And do their contract provisions and liability extend appropriately down the chain to those sub-processors? This is essential for understanding your overall supply chain risk exposure.
Wow, the supply chain risk is complex. What about data allocation?
Huge issue, especially with international laws. Ask, where will your data actually be physically stored, processed, and transmitted? What specific countries of origin will be involved? And what are the legal, regulatory, and geopolitical implications of those data residency locations, especially regarding privacy laws like GDPR or potential government access concerns?
Date residency matters. What about when things go wrong? Incident response.
Absolutely critical. You must understand the vendor's incident response process before an incident happens. Ask, how will they detect, contain, analyze, and recover from a security breach affecting your data or services? Crucially, how quickly will clients like you be notified of a potential security incident involving your data? What are the agreed-upon timelines and communication channels? Are there specific notification requirements baked into the contract?
Don't wait for a breach to figure that out.
Never. And finally, what contractual provisions are in place to ensure the ongoing integrity, availability, and eventual return or destruction of your data, especially at the end of the contract term? When you outsource something critical, it's exactly like trusting a third-party warehouse with your most valuable inventory. You need to ask them a lot of detailed questions up front about their security measures, who else they work with down the supply chain, and have clear contractual agreements about what happens if there's a problem, because their security directly impacts your security, your compliance, and potentially your entire business.
That's a fantastic overview of vendor due diligence. So after covering all that ground, what does this all mean? It's time for our recap. We've covered a lot today, diving deep into the intricate and often overlapping world of laws, regulations, and compliance specifically as they impact the field of cybersecurity.
We certainly have. Let's try to quickly reinforce the key takeaways for everyone listening. First, remember the three main categories of laws that define the U.S. legal system we discussed at the start. There's criminal law, which forms that bedrock of public peace and safety, prohibiting offenses like digital theft and hacking, and carrying serious penalties like fines or imprisonment.
Right. The state versus the individual.
Then there's civil law, which handles disputes between individuals or organizations, often resulting in financial consequences or court orders. This is crucial for things like breach of contract lawsuits or data breach class actions seeking damages.
Private party versus private party.
And finally, administrative law, which consists of the rules and regulations enacted by executive branch agencies to carry out their mandates. This is vital for understanding many specific compliance standards, like the NIST guidelines developed under FISMA authority. So, quick memory aid. Criminal is public peace, civil is private disputes, administrative is agency rules.
Excellent summary of the three types. What was takeaway number 2?
Second, we examined the evolution of key computer crime laws designed specifically for the digital age. We started with the granddaddy, the Computer Fraud and Abuse Act, the CFAA, as the first major piece of U.S. cybercrime-specific legislation. We traced its expansion from focusing narrowly on federal systems to eventually covering almost any computer used in interstate or international commerce, and even addressing the creation of malicious code.
CFAA, the foundation.
Exactly. We also covered the Federal Information Security Management Act, FISMA, which mandates comprehensive information security programs for all federal agencies and their contractors, with the National Institute of Standards and Technology, NIST, providing the vital blueprint and guidelines for implementing those security practices. So think of CFAA as our core digital property crime law, and FISMA as the foundational federal government security framework.
Got it. Third key area.
Third, we explored the crucial world of intellectual property protection, which safeguards those valuable intangible assets vital to the modern innovation economy. We discussed the four main types. Copyright for original creative works like software code, protecting the specific expression, not the underlying idea.
Copyright for code.
Trademarks for identifying brands and preventing marketplace confusion, like company logos or product names. Patents for protecting new, useful, and non-obvious inventions, granting the inventor exclusive rights for a set period. And trade secrets for critical business information that derives value from being actively kept secret, like a proprietary formula or manufacturing process. So remember, copyright for creative works, trademark for brands, patent for inventions, and trade secrets for valuable business secrets.
4 distinct types of IP. Okay, what was fourth?
Fourth, we delved into the complex and rapidly expanding global privacy landscape. We highlighted the significant impact of the European Union General Data Protection Regulation, GDPR, and its wide-reaching implications for organizations worldwide handling EU resident data, emphasizing concepts like its broad scope, strong individual rights including the right to be forgotten, and strict rules around cross-border data transfers.
GDPR's global reach.
Right. We also touched upon key U.S. privacy laws like HIPAA setting strict rules for healthcare information, the Electronic Communications Privacy Act, ECPA protecting digital communications from interception, COPPA safeguarding children's online privacy, and the CLOUD Act addressing cross-border data access by law enforcement. We also looked briefly at other international laws like Canada's PIPEDA, China's PIPL, South Africa's POPIA, and the rise of state-specific privacy laws like California's CCPA, reinforcing that privacy compliance is a truly global and often fragmented challenge.
A tangled web of privacy rules. And in the final key takeaway.
Finally, number 5, we stress the paramount importance of compliance itself. As cybersecurity professionals, you must be deeply aware not just of technical threats, but also of the legal, regulatory, and industry standards that apply to your organization based on its location, industry, and specific business activities. We use the Payment Card Industry Data Security Standard, PCI DSS, as a prime example of a non-governmental yet contractually mandatory compliance requirement that organizations handling credit card data must adhere to, facing stiff penalties for failure.
PCI DSS is a key example.
Exactly. And we concluded by highlighting the critical role of vendor governance in contracting and procurement. We emphasized that when you outsource data handling or critical functions, you effectively extend your trust and therefore your security and compliance perimeter to those third parties. This necessitates thorough initial due diligence and ongoing monitoring to manage that significant supply chain risk.
That's a fantastic recap of a dense topic. It all really raises an important question for everyone listening. How do you, as a cybersecurity professional, effectively integrate this constantly evolving legal and regulatory knowledge into your daily work, your risk assessments, your control designs, your incident response planning?
Right. It's not about trying to be a lawyer.
No, definitely not. It's about being legally informed, understanding the requirements and risks, knowing the boundaries, and crucially, knowing precisely when to raise your hand and seek professional legal help when navigating these complex and sometimes ambiguous waters. Your role is absolutely crucial in bridging that gap between technical implementation and legal or regulatory adherence, ultimately safeguarding both your organization and its valuable data.
And perhaps if we connect this to the bigger picture, think about this. In a world where data flows instantly across borders and technology like AI and quantum computing evolves at lightning speed, how do we ensure our laws and regulations can possibly keep pace? What new legal and ethical challenges do you, the listener, foresee emerging as these powerful technologies become mainstream? And maybe more importantly, what role do you play through your daily work and advocacy in helping to shape that future through responsible, ethical, and legally informed security practices?
Powerful questions to ponder indeed. That's definitely food for thought. Thank you for joining us on this deep dive into the complex but critical world of laws, regulations, and compliance.
My pleasure. It's essential knowledge.
Until next time, keep listening, keep learning.